Good afternoon and welcome to the March Q&A virtual lunch hour with Jason Killeen. My name is Jason Killeen and I'm the Assistant Executive Director with the Department of Cannabis Regulation, overseeing the department's licensing functions. Unfortunately, we have to be in Personnel Committee at 1 o'clock, so we're going to have to cut today's Q&A session a little bit short. So we're planning on ending sometime between 12:30 and 12:45. But we hope to get through as many questions as possible as part of this go around. So with that, we can go ahead and jump into the questions.
Good afternoon, everybody. Our first question comes from Averia F. How do I open my own dispensary?
So opportunities to apply for the retail storefront commercial cannabis activity are limited to folks that were selected to participate in either phase 3 retail round 1 or phase 3 retail round 2. We're hoping to conduct a future lottery to create another round, but at this time, we are not accepting applications from folks that were not selected outside of phase 3 retail round 1 or phase 3 retail round 2. We do have information on our website about what activities are available and what folks can openly apply for. And then, of course, for retail storefront, non-storefront delivery, and cultivation activities, you do have to be a verified social equity individual applicant through the remainder of this year.
Thank you. Our next question comes from Victor G. How much are all the fees combined, and how long do I have to submit my application?
The most basic fee is the land use review fee, which is $597. In order to submit a pre-application review record, you have to have a legal business entity record. The review fees for the legal business entity record vary depending on whether you're applying as a general applicant or a social equity applicant and going through the equity share review. And then the application fees themselves are over $7,000 per activity. And then, of course, folks applying for the retail storefront activity would be paying for community meeting fees and public notice fees and other things associated with that activity. All in all, it's probably over $20,000 to apply for one activity. And each of the cost goes up by about $10,000 per activity if you're going to be applying for more than one activity on location. And that's only the DCR fees.
Thanks, Jason. Next question from Marty V. Which counties allow Type 9 licenses?
So our department only has jurisdiction over licensing within the city of Los Angeles. However, under California law, our licensed dispensaries may deliver into other jurisdictions throughout the state. If you're looking for which counties are accepting retail and non-storefront delivery applications, I would recommend going to the Department of Cannabis Control's website.
A question from Yongq. Why do I need to have a building ready to apply for a retail store scheduled to open around April?
Yes, you would have to have gone through the pre-application review and had the location deemed eligible for further processing, plus have an application that, was granted temporary approval, which requires you to pass an initial inspection at a specific location before you can lawfully operate. We do have our application procedures and various resources on the DCR website. So I would recommend that you look at the procedures to make sure that you followed everything. Otherwise, you would be engaged in a licensed commercial cannabis activity and subject to enforcement actions by LAPD, Building and Safety, DWP, et cetera.
Ken S. asks, can you describe the current process and likely outcome for moving an existence licensed dispensary from one location to another?
It's going to depend. So first, you have to have been issued a license. So a business that does not have temporary approval is not eligible for relocation. Secondly, when you submit your relocation modification request, you'll have to identify a location that meets the land use requirements as well as the relocation requirements into the code. So for instance, a retail storefront license may be relocated within the same community plan area that it was originally issued in, or you may seek relocation to a community plan area that has not reached undue concentration. When the relocation modification request is processed, if it's deemed eligible for further processing, then you would have to submit an application for that location. And as part of that process, you would have to give up your current location. So most likely, if you were seeking to relocate an active business, there would be downtime between when you stop operations at your existing location and as you navigate through the process to get a license at the new location. If you're not a social equity applicant, you will not be eligible to get a provisional license from the Department of Cannabis Control, which means you have to get an annual license from the city before you can meet the licensing requirements for the state. So, if you are an existing licensee and you are looking to relocate, you'll have to look at the ramifications at the local level as well as at the state level for what that process would be, because you need both sets of licenses to lawfully operate.
There's another question from Ken S. Can you describe the process for adding a new owner and what are the requirements for an existing owner remaining as a member or shareholder or officer or director without having to file a new application?
Ownership modifications are submitted against the legal business entity record. And then the modification request is reviewed in conjunction with the code. There's general applications where there are no restrictions on how the equity can be transferred. And then there's social equity licenses where the aggregate equity share amount must be held by a certain number of social equity applicants to have whatever the mandatory percentage is for the specific tier assigned to the application, whether it's 51% for new records and tier one records, or 33%, 33 and a third percent or more for the phase two records. Again, I would recommend reaching out to your licensing analyst. The primary personnel, the owners that stay on the record, all become part of the review, but it's hard to give you a catch-all answer because there's different scenarios where you have to consider different things. Like, do you have the requisite equity shares assigned to the social equity applicant for it still to be approved and be an equity share license? Or, do you have at least some connection to the original ownership group so that there's no discontinuation in operation while we work on your modification request? And lastly, when we talk about ownership changes, the applicant or licensee has to remain the same. So if you're converting from a corporation to a limited liability company, that's a completely new entity, which requires a completely new application.
Thank you, Jason. Our next question comes from Lavelle T. It's a two-parter, so let me go ahead and ask it. How does one find insurance for a cannabis business entity / location? And what is the average business investment amount needed to enter into a business?
So I'll start my answer with, DCR cannot provide business advice. If you are a social equity applicant, you can reach out to get a referral to our pro bono program with LACBA. Dr. Brown and her social equity team also have an abundance of resources that are intended to assist prospective applicants in, how to form a business corporation, how to do job interviews, how to look for these things that folks would need in order to start a business. And then separately, it costs several $100,000s to navigate through the application process at the local level, the state level, plus pull the permits and secure the location while you're going through the permitting process. So you would expect to spend at least 6 to 7 figures just to be able to enter into the commercial cannabis market.
Next question comes from Michael W. We are in an industrial complex with over 20 units. Can we obtain a license even if a business next to us objects to our business?
And the simple answer is yes. Ultimately, the department makes a land use determination based on the requirements set by the municipal code. And then we process the application in accordance with the municipal code. So somebody not wanting you to operate next to them would not be a reason for the department to deny your application. And it would have to be for one of the enumerated reasons that are listed in the municipal code.
This question comes from Jesse F. Are there any updates available on the next lottery round and the next round of cultivation licenses?
Not at this time.
From Deirdre H. If I have missed the window to apply as an SEIA applicant, may I still apply for manufacturing and delivery license as a non-social equity applicant?
For the manufacturing activity, you would be able to apply for it as a general applicant. Non-storefront delivery is limited to social equity applicants through 2024, so you would not be able to apply for that activity at this time.
Our next question has a few parts. If you need me to repeat any part of that, Jason, please let me know. Coming from Flora G, we are a retail location without a state license, and we are not doing any changes to the facility. Previous use was a retail vitamin shop and no environmental review needed for us. Do we still have to wait 90 to 180 days for our community meeting and public hearing? And how can I get exempted and have an earlier hearing?
So keep track of my response, and if I miss anything, let me know.
Will do.
So the changes to the facility will impact the types of building fire permits that you would have to pursue, which is outside of DCR's purview. The fact that you might have a certificate of occupancy for the location for retail because there was previously a vitamin shop there may allow for you to not have to go through building and safety or to get a clearance from building and safety for the retail component. But because every commercial cannabis license is a discretionary license, DCR is required under the California Environmental Quality Act to do an environmental review to determine whether or not you would qualify for a categorical exemption. So when the application is filed and we transmit the completed Form 4013 to one of our environmental consultants, those are being routed based on when it's received, as well as what's already in the queue. So we already have our consultants oversubscribed in processing those 4013 forms for the remainder of 2024. And that has to be processed. We have to have an environmental document to approve in order to issue a notice of complete application. So once we've issued the notice of complete application, we do have to schedule you for a community meeting. We do have to schedule you for a public hearing. We have to provide 20 days notice in advance of those hearings. So, even if you were able to qualify for a categorical exemption, you have a certificate of occupancy, you would still be waiting at least 90 to 180 days to get through the process. And there is no ability to get exempted from this review process because it is set by the municipal code. It would require the city council and the mayor to amend the municipal code to exempt commercial cannabis businesses from that level of review.
Thank you, Jason. Moving on to question from David W. I am a phase 3 round 2 tier 1 lottery selectee. What is the limit on the number of retail licenses I can hold?
The municipal code limits a person to be an owner of up to 3 licenses. So you're considered an owner if you have 20% or more equity in the applicant or licensee. So if if you are the qualifying SEIA for the phase 3 retail round 2 and you're listed as an owner, that counts as one of the 3 that you could hold. But each individual selected through the lottery is only able to apply for one license as part of that lottery selection.
Thank you, Jason. Joel G asks, is the department going to accept more application? If it is, when?
The department is preparing an omnibus package for city council consideration to update the municipal code and make several recommendations to hopefully streamline and simplify our regulatory process and procedures. And we hope that city council will be able to take it up sometime in the summer or fall. So based on those policy decisions that are yet to be made, that's going to drive when we would accept more applications or when we conduct a future lottery.
Our next question from Maggie E. I'm on the board of the International Cannabis Women's Association for California. For an out-of-state organization, do I need to register in Connecticut to have an event?
So the city of LA only regulates things that happen within our jurisdiction. So we don't have any jurisdiction over a Connecticut event. The Department of Cannabis Control, the state agency, regulates events that happen within the state of California. The one thing that you have to do is one, register as an event organizer with the state. The city doesn't issue an event organizer license. And then you have to get a special event permit from the state and then from the local jurisdiction to hold an event within that jurisdiction. So if you're planning to hold an event in Connecticut, I would recommend you reach out to the regulatory agencies in the city that you want to hold the event to see what their requirements are.
Thank you. Jesse P. asks, how can I learn to develop a plan for a micro business and about the social equity program?
So there's a lot of resources on the department's website related to the social equity program. If you are a verified social equity individual applicant, you would have access to the learning management system, which has various courses associated with what it takes to develop a business plan and who you need to talk to. If you have questions about your social equity status or whether or not you would qualify, I would recommend emailing dcr.sep@lacity.org.
Jorge T. asks, does a retail storefront annual record that is non-operational create a sensitive use buffer or count towards undue concentration?
A filed application creates a 700-foot sensitive use buffer between the business and any other business seeking to engage in the retail storefront activity. A location does not count towards undue concentration until a license is issued. So if an application has been deemed filed, it would plant a flag, create a buffer, which would preclude other businesses from applying within 700 feet of its approved location, but it would not count towards undue concentration until they meet the requirements to be issued a license.
This question is a follow-up from Jorge T. Is a retail location that no longer has site control and is now listed for rent create a sensitive use buffer? Can a location still have site control even though they no longer occupy the building?
So that's a two-part question. Businesses that lose site control are required to submit a business premises surrender form. which would result in the abandonment of the underlying record. Once the record is abandoned, then they're no longer considered a sensitive use. There is no buffer from that location. It's no longer an active application. If a business does not submit a business premises surrender form or notify DCR that it's no longer able to move forward at the location, it will remain a buffered location until the application is either abandoned for another reason or we get information from the business that they no longer want to pursue a license at that location, at which point we would make the necessary adjustments on the application record and then remove that business from our map. A business could still be in negotiations with the landlord to extend their lease or to secure their lease for a longer period of time. And they may be competing for that location and they may not have given it up. So we don't get into the private business dealings between the landlord and the tenant. We rely on the applicant to notify us of what their status is, and then as part of the renewal process, provide us documentation that they do have site control of the location to renew their record or renew their license.
Our next question comes from Jen M. Are the purple question marks on the current licensing map considered sensitive use?
That's a great question. The purple pins are things that may be considered a sensitive use when we do our land use review. When you click on one of the purple pins, it tells you what the potential sensitive use could be, and it provides you some detailed information about the location. The purple pins are different from the icon that looks like a parent and a child, which is schools. So the schools apply to all applicants. Retail storefronts have to be located outside of 700 feet of a school. For non-retail activities and non-storefront delivery, it has to be at least 600 feet away from a school. And then the purple ones are for a variety of things that may rise to the level of being a sensitive use that only retail storefront businesses have to be concerned with. A few of the sensitive uses have multiple things that have to be reviewed. So for instance, a daycare, a location could have a daycare license, but if that license is associated with a residentially zoned property, it's not considered a sensitive use. So if we see the purple marker and it's associated with a daycare, we look to see the zoning for the parcel that it's associated with. And if it's a commercial parcel, manufacturing, industrial, it would be considered a sensitive use. If it's a residential parcel, then it wouldn't be considered a sensitive use. For permanent supportive housing, it has to be occupied and it has to provide on-site services. So when we do the land use review, we look to see whether or not a certificate of occupancy has been issued for the location and whether or not they provide on-site services. The adult use and treatment facilities, it has to be non-medical residential services, verify the license, verify that they provide the non-medical residential services before we make the determination of if it is a sensitive use. So hopefully that helps.
This is a follow-up question from Jen. How can we determine what CPA we are looking at in the new licensing map? Jason, did you hear my question or are you pausing to think?
I heard your question.
Okay.
I muted myself and I apologize for that. I'm going to bring up the DCR licensing map so that folks can see what I'm talking about. Are you able to see the licensing map page?
Yes.
So for the earlier question, they were talking about the purple question marks. What we do is we download sensitive use data from the different governmental agencies, and you know, we populate the map based on those sensitive uses. So like you can see here, Agua Dulce, there's, these are most likely daycares. This is actually Vasquez Rocks, which is a park. These are things outside of the city. So not everything that appears on the map is actually a sensitive use that would impact a prospective applicant within the city. We're just taking this aggregate data from the state, from the identified databases, and pulling it into the map. When we get a pre-app review record for a location, we actually go in and we do the review of everything within the 700 feet of the location. So you can see here, this is one of our phase one applicants with temporary approval. And then you can see that, we did the verification to make sure that the school over here is outside of 700 feet. We would have done the verification that this daycare is outside of 700 feet. We look at that geographic area when there's a record before us that requires the use. So things that are on this map may or may not actually be a sensitive use. We're putting it on the map because it was in a government database and it could rise to the level of being a sensitive use. And we do that review when we actually have a record that would be impacted by that particular data point. So hopefully that helps. Separately, when folks are in our map, there's this little button over here which will bring up the window so you can toggle it on and toggle it off. When you go down, you have various sensitive use layers that you could turn on. So the city council districts is defaulted on. You could turn that off. You have the community plan areas. So you can see this. You can toggle it on, toggle it off. If you touch the yellow, it'll actually bring up information about the layers. So this particular layer is associated with the Sylmar community plan area. And you can also look at the neighborhood council boundaries. So if I zoom out, I can get us into one of them. Let's see. I'll just do this one. You can see this is Granada Hills North. It's got information from the Department of Neighborhood Empowerment for which neighborhood council this is. That will have additional contact information, et cetera. So there's a lot of information and resources on the website. It's really just a matter of you as a user toggling on and toggling off the information that you want to look at. So we have everything defaulted on. And then when you come in here, if your primary concern is, community plan area, seeing what the boundaries are, which community plan area you're looking at a location in, you can go ahead and do that. You can go ahead and use the navigation bar up here to open it in a new window. And when you get into the new window, you'll actually have a search bar up here. If you click on the magnifying glass, and then you can enter any particular address you want. And then it'll move a pin to the location. So this is the DCR headquarters. And then you can get information about that particular spot. So you can see there's really no sensitive uses within 700 feet of our DCR office that would preclude us from doing the analysis. You can do the zoning review. You can look to see what community plan area it is. This is in, the downtown Los Angeles neighborhood council. We click on borders. Let's see. This is part of the Central City community plan area. Depending on what layers you have up is going to depend on what information gets displayed when you click somewhere on the map. And again, when you have the little purple points over here, it'll tell you what the name of the sensitive use could be. So for this one, it's a park. It's got the name of the park. And then, of course, you can use the mapping tools to zoom in to identify, okay, is this a park that meets the definition under the municipal code? So hopefully that's helpful. And I toggled back into the presentation. So if we want to jump into the next question, by all means.
Thanks, Jason, for walking us through that. The next question comes from Charles D. Is there a license for any cannabis business in which you can use your residence as a base?
No, there's not.
Next question comes from Anahi T. Would DBS allow cultivation activity on the sixth floor of a building?
Potentially. I mean, we've seen cultivation activity on the third floor of the building. I mean, it really is going to come down to whether or not you can meet the building code and fire code requirements and what type of activity you're engaging in, what tenant improvements you need to do, and what type of operation you're running. You know, what is that footprint? You know, can the building and that floor support the activity that you're trying to do?
This is a follow-up question from Anahi. Is there a cannabis-specific planner at DBS, Department of Building and Safety? I find working with DBS a challenge.
So the Mayor Bass and her team have implemented various executive directors to try to help streamline the permitting process across multiple agencies. One of those new programs, I believe it's called the Restaurant and Small Business Express Program. And cannabis businesses can go ahead and submit to participate in that program. And that would create kind of a project plan team that would help you navigate the permitting process. There's various departments that have subject matter experts that participate in the restaurant and small business enterprise program. And there's information on the Department of Building and Safety website. So if somebody on the DCR team could find the link to the website and just drop it into the chat so folks have it, you could reach out directly to them and then ask for a referral into that program. And then if you are a cannabis business, they would reach out to DCR to see whether or not you have a pending application and you would be eligible to participate in those services.
Great. The next question comes from Mike S., and it has several parts. Can you please discuss in as much detail as possible the following DCR deadlines? First, by when does each license type need to have passed the health department inspection? 2, when do retailers need to have their emblem? 3, by when do licensees need to have a correct certificate of occupancy? And lastly, do any of these deadlines vary if the license is a social equity applicant?
So the kind of as a matter, the deadlines are fixed for general applicants and social equity applicants. Can you, I'm going to need you to repeat this one because it was really
Sure.
detailed.
Sure. So the first part is when does each license type need to have passed the health department inspection? That's one.
Okay.
The second one is when do retailers need to have their emblem?
Okay.
Third, by when do licensees need to have certificate of occupancy?
Okay.
And then the last one, you answered it as far as the varying deadlines between social equity in general. So that one's done.
Okay. So having the certificate of occupancy is part of the clearance process to get your health permit. And for the retail storefront activity, once you're eligible for your health permit for that activity, you'd be eligible to also get your emblem. So the certificate of occupancy really becomes a prerequisite to meet all of the requirements necessary to get your health permit. The second thing is for the emblem program, the emblem only applies to the retail storefront businesses. And the retail storefront businesses have to have the emblem because they are selling to consumers prior to other applicants having to have their public health permits. So any business premises that has a license or temporary approval to conduct retail storefront activity may not operate without that emblem beginning on January 1st of 2025. So the first boot to fall is going to be, you're going to make sure that you have a certificate of occupancy covering the section of the building where you have the retail storefront activity going on so that you can go through the public health permitting process to get your health permit and your emblem. And you need to do that by January 1st of 2025, or you have to stop operating until you actually meet the emblem placard requirements. Separately, we have deadlines for the non-retail activities that off the top of my head, I don't remember what the deadline is for non-retail. So I can touch base with that on a future webinar. But I know it's not January 1st of 2025. The issue that folks are going to have is when you get your annual license, you either need to have temporary approval or an operating permit as your local form of licensure to go along with your state license. For businesses that aren't eligible for temporary approval, they're not going to be able to operate until they have an operating permit. And in order to get an operating permit, you have to pass a final inspection. To pass a final inspection, you need to demonstrate that you have all of your permits, health permits, certificate of occupancy, fire permits as necessary. So for folks that are coming into our process that can't apply for a temporary approval license, you will have to go through all of that before you qualify for the final inspection and qualify for an operating permit. So some of the deadlines are driven by code for existing licensees, and then some of them are driven by the fact that you can't advance to the next step without actually first having obtained it, which means that a lot of new businesses coming in are not going to be able to get licensed until such time they've met the certificate of occupancy requirement, the health permit requirement, potentially the emblem requirement, final inspection, operating permit.
Thanks, Jason. I just wanted to check on time. It is 12:40. We have 3 to 4 questions left. So here you go. Mike S., is there an upcoming March 31st, 2024 deadline as far as requesting the health department inspection?
Yes. So the LA County Department of Public Health had DCR negotiated with them to basically offer a more expedited review so that our existing licensees wouldn't have to go through plan check review and a site evaluation. If you submit the documentation necessary to public health, you can bypass plan check review and go straight into site evaluation. It's a more streamlined process. It's less costly. If you do not get into their program by March 31st, you will ultimately have to go through the plan check review and then site evaluation before you could be eligible to receive your health permit from them, which means that you will have to pay additional application fees to the Department of Public Health, and it will be a lengthier process because you have to get through plan check before you can get into the site evaluation.
Next question from Leah or Lee L. How can we get in line to speak at the community meeting of a retail business?
So all of our community meetings are done virtually. On our website, under the notice section, there's information about the community meetings that have already been noticed. Our first community meeting is tomorrow. And then because we're doing them virtually through Zoom, basically we'll use the same functionality that we use for our commission meetings where folks will indicate that they want to speak. Speakers will have up to 2 minutes to speak, and then we'll go to the next speaker. And then we'll continue that process until we run out of time.
Another question from MS. When can local non-retailers expect to receive official CEQA exemption and annual license from DCR?
Later this year. So DCR is still trying to get its budget modification approved by the Department of Cannabis Control to utilize the LJAG funds to waive as many fees as possible. At this time, DCC has only said that they'll approve the categorical exemption fee, which means that there's still tens of thousands of dollars that folks would have to pay for the other fees in the code. And we hope to have resolution of it before the end of this month. But effectively, if we're unable to use the LJAG fund to provide fee waivers for everything, we will begin the process of issuing invoices for annual license application fees, community meeting fees, noticing fees, etc., as it relates to the record. And then folks will have the 30 days to pay the applicable fees. And then that will kind of get those non-retail applications in the formal queue to go through and get processed. For the official CEQA exemptions, we have our environmental consultants submitting bids for different batches of applications throughout the city. And those batches are built around the state expiration dates. So we do need to have the proposed environmental report that can go along with the staff report to go to the director for non-retail and then to the commission for the retail storefronts. So you can't really get to a notice of complete application until we've done that analysis and we actually, confirm that the information in the 4013 form is sufficient to get the environmental clearance for the record.
Thanks, Jason. We're at 12:44. I'm assuming that you're going to have to cut it off to get to your meeting.
I'll go through quickly for the next couple, just to clear out the question queue if possible.
Okay. Stephen D. In the event that there is a problem with a landlord after paying the temporary approval fees, is there an option for a refile to relocate?
If it depends. If it's an initial application and you've submitted your temporary approval application, you lose site control, you submit the business premises surrender form, DCR may be eligible to abandon that location. And if the application was deemed filed before it was abandoned, you may have the opportunity to refile. A refiled application cannot be further refiled, so you only get one opportunity to refile. If you paid the temporary approval fee, but you never submitted a complete application, then the application was not deemed filed. It's not eligible for refiling. I would recommend reaching out to your assigned analyst for more details about that specific record.
Stephen D. also asks, will there be any more opportunities for cultivation?
If we make cultivation available, it would be done through a lottery. At this time, cultivation is restricted to social equity applicants, and there's so few cultivation opportunities remaining. It would only make administrative sense to offer them via lottery like we do for the retail storefronts. And then, of course, there's nothing in the code that sets forth how a lottery would be administered for the cultivation activity. So that's part of our omnibus package.
1246, Jason, there's 3 more questions in the queue.
And we'll do them as quickly as possible.
Okay, Ariel J. When will the non-retail notice of complete applications start being issued?
End of this month, beginning of next month, for our retail storefront businesses that are vertically integrated that already received a notice of complete application for the retail storefront activity. You should expect to start seeing the notice of complete application for those non-retail activities later this month. We do have to summarize the community meeting input into the staff report for the retail storefront. And then we'll be finalizing the environmental report for that location. And that same environmental report will be used for the complete application for the non-retail activities that go to the director. For other folks, it really is going to come down to when your state provisional is expiring, and then how quickly the assigned environmental consultant is able to get us the analysis for your project.
Ariel J asks, when will the 2024 temporary approval certificates be issued?
Later this month. So the team, everybody knows that the late renewal process ended on February 29th. We're still reconciling with the Office of Finance whether or not there are any outstanding mail payments that need to be processed, but our team is closing out expired records, updating statuses and stuff. So we intend to do a batch job for the electronic 2024 temporary approval PDFs that'll be uploaded directly to the applicant's record later this month.
Final question from MS. Are social equity retailers also subject to the January 2025 deadline to have an emblem?
Yes, they are. So effective January 1st, 2025, every retail storefront operator needs to have an emblem, or they need to cease operations until they have their health permit and their emblem.
Thanks, Jason.
Thank you for coming, everybody. I apologize that I do have to duck out early. I have to get over to City Hall for a personnel committee meeting. Our next Q&A virtual lunch will be on April 10th at noon, and I look forward to talking to everybody then. Have a great day.